Stanford University.
This program is brought to you by the Stanford Humanities Center. For more information, please visit us at shc.stanford.edu.
So I want to start this morning by talking about what's actually, I think, a fairly familiar topic for us, and I know you discussed it a bit in sections yesterday. I want to start by talking about the constitutional crisis of 1937, also known in the vernacular as the switch in time that saved nine, because the Supreme Court kind of flipped its jurisprudence, in effect, in the case of West Coast Hotel versus Parrish. And in a sense, from that point on, the court starts backing out of the way of attempting to impede or regulate or circumscribe the way in which the New Deal was going to go forward. So it's a crisis that's really kind of determined by two factors. I mean, one was the way in which in 1934, 1935, 1936, after some initial deference, the court, for a variety of reasons, partly out of a kind of conservative political ideology, partly because maybe much of the New Deal legislation had been drafted in haste and was defective, partly because there's anxiety about how much authority should the Congress, of a lawmaking nature, rulemaking nature, should Congress delegate to the president, partly out of an adherence to the traditional ideas about substantive due process, the legacy of the Lochner era, and so on. So 34, 35, 36, the court effectively guts a big part of the New Deal program. It didn't put the nation back on the road to depression. In fact, for a variety of reasons, the economy was improving from one year to the next. 1937 started out as a not very bad year economically, some signs of recovery. But a big part of the, major parts of the New Deal were gutted by those decisions. So that's fact number one. Fact number two, this is a great case of what our former colleague Larry Kramer called the verdict of the people themselves. The Democratic Party by 1936 was becoming a dominant political party, capturing both houses of Congress, capturing the presidency in a radical way, losing only Maine and Vermont. And so Roosevelt, who was, of course, politically a genius, kind of the, political terms, as influential a president as any the nation has had behind him a very strong body of public sentiment. And so one upshot of this is that on the one hand, the court was, is adhering to his policy, basically with the kind of, 4 conservatives, 3 liberals, two swing voters. And Roosevelt, is attempting to muster, some basis to overturn the court's policy. And, the famous example of this, and, the controversial part, was the famous court packing scheme, which would have provided that as the court gets older, for every member turning 70, you would add a new member to the court until the court reached the size of 15. So, over time, it would take a few years, but over time you could adjust the balance in the court. That idea proved deeply, deeply controversial. FDR actually by 37, 38 was having increased difficulties maintaining political leadership within the Democratic Party. There are conservative Southern Democrats, then as later, who did not fully adhere to the kinds of positions he represented. But on the other hand, whether or not the court packing scheme was a great idea in its own right, and it has had that many fans, in the course of American history, there's still the underlying political verdict. And the underlying political verdict says that the Democrats have won a decisive majority. They've controlled they control Congress. They control the presidency. The people they control many of if not most of the state governments. There has been a major progressive swing to the left of American politics. Do the people not have a right to rule themselves, to some extent independent of time-worn, somewhat shop-worn judicial doctrine? So that's kind of the background. Now, that's a fairly obvious part. There's a bit of a detective story here. It's not clear wholly how to play it. So the two swing justices here, and actually, you guys may have to help me out in case I get the name screwed up. Are Jones and Roberts. And since our slide system has crashed, with apologies to people out in podcast land or whatever, C'est la vie. Maybe we'd add this in later in any case. But, we looked at a photograph of these guys the other day. So the question, there is a technical question here which is still being somewhat agitated. Did the court packing scheme trigger the change in doctrine, or what we call the switch in time that saved 9? Part of the story has to do with when Justices Jones and Roberts, with Mrs. Jones and Mrs. Roberts, went off to the Poconos. I'm sorry, no. To the Poconos? Are we talking about the same trip? No, I think it's okay.
The moderate swingers were
right.
Yeah, there was never a Jones on the court.
Said Jones. Yeah, why did I say Jones? Okay, Stone and Roberts. Okay. It's a story about whether they go after the Poconos with their wives and how much time they spend there in kind of serious deliberation about where the court ought to go. There's a discussion whether did this trip take place in 1936, which might make it significant, or earlier 37, or 1935, which would lose its significance. I don't know. And people are still arguing about this. I don't think we really have a big stake in this. The other point that's made is that the essential decision in the case of West Coast Hotel versus Parish is another one of these minimum wage cases coming out of the state of Washington. It's at the very end of the book we read last week, whether that decision was not made in conference before the whole story blows up. Before the whole court packing scheme is announced and pursued. It's kind of technical stuff. It doesn't really matter. I mean, the key thing is in the court in West Coast Hotel versus Parish, minimum wage case involving a chambermaid from the state of Washington, makes its major move, accepts the kind of legislation it had been striking down, and that case is seen, I think correctly, as kind of the pivot, the turning point. Marking the point at which the court is going to abandon, or the court is going to move away from the very kind of the jurisprudence, the Lochner River jurisprudence had been following over the previous 3 decades. Basic political story, I think it doesn't pivot on going to the Poconos, still a popular honeymoon spot for people on the East Coast. It doesn't pivot on going to the Poconos. It probably does not pivot on the ups and downs of the court packing plan. It probably does pivot on the election. That's, I think, the decisive fact. And, on the whole, that's probably a good thing. That's to say, if you believe in democracy as a fundamental value, the idea that you'd have repeated tests of different ideas about how government should operate with decisive majorities coming down on one side, I'm perfectly comfortable with that, not just because I'm a New Deal Democrat, by birth. That's the easy part. But it seems to me it goes back to that kind of fundamental conception of the nature of constitutional governance that I think in some ways we can date going back to the late 1780s. People like James Wilson, I think to some extent Madison, understood that in effect the federal system we had established consists of 2 levels of government whose authority would overlap, which would in some ways exercise parallel and overlapping functions. You could not draw, if you remember the logic of Federalist 37, you could not draw perfectly neat, symmetrical, concise boundaries around the respective spheres of power. In some sense, the capacity to organize and maintain national political majorities would become the best test of who had the right to govern or who had the right to pursue the policies that wish to be pursued. So if you see the 1930s, as I said, going back to actually when the Democrats took the House over, I think in 1930, if you see the repeated elections as an ongoing test of the validity and the depth of the political mandate, and you think about the depth of the problem the nation was facing, it's not inconsistent. That's a pretty weak statement. I think it's fully consistent with the original animus of the Constitution. It says we're going to have 2 levels of government, and ultimately the tension between them cannot be solved by jurisprudence, can't be solved by Supreme Court. If you can actually muster and mobilize national majorities over a prolonged period, because our whole system of government makes that a difficult enterprise to do, then you should have the right to govern on the basis of that kind of political success. So forget about the Poconos. If you ever want to go, it's nice, but not a big deal. It's not the Sierra, so we don't have to worry about it. Don't worry about the court packing scheme. Think about the fundamental nature of political conflict over the nature and substance of the Constitution, which in effect was what the 1930s were about. So West Coast Hotel versus Parish was the starting point for this. And then, what happens afterwards, of course, is that there's a whole slew of decisions that work out the doctrine. And I want to talk about two of them as we go along here. The first one, the one that legal scholars, I won't say historians, but the one that legal scholars, in fact, I'll tell you a little story about this. The one that legal scholars are most interested in is this funny case about called U.S. versus Carolene Products, which involves the shipment of something called filled milk, in which coconut oil has replaced butterfat across state lines. I think it's an Illinois statute that's in jeopardy, and the court is basically saying Congress has the authority to prohibit the shipment of filled milk, whatever it is, whatever purpose you use it for. Maybe it's maybe it's like using lard, which is very popular in baking in Florence, Italy, but not in other places, whatever. So the case is wholly obscure by itself. And a little story about this. Years ago when I taught a versus course, and we had a graduate oral exam for a student of ours who had been the TA in this class, a guy named Joe Crispino, who's now at Emory. And because he TA'd the class, Joe knew a lot about Carolene Products and its significance, which I'll explain, in 1 minute. My colleague David Kennedy, and Joe mentioned, of course, some question I was asking him, and David Kennedy, my very distinguished colleague, who has written the Pulitzer Prize-winning book on the New Deal, didn't know the case, which I thought was kind of interesting by itself, but I don't hold that as a demerit on David's part. It has to do with the idea that Carolene Products matters a lot for legal scholars. It's really pretty trivial for historians. There's no real reason for, there's a whole slew of cases that come out of the Supreme Court in the late 1930s, which developed the modern commerce doctrine. Carolene Products was not significant in and of itself, just one case among many, except for the famous Footnote 4, which appears. And so let's actually, this is something I think we want to spend a little time talking about. So let's flip over to the backside of the outline, because this is not the most lucid judicial prose that we're ever going to encounter. But to understand what's going on here is really a good sign of the way in which the legal doctrine was going to develop. And I said something about this the other day on Wednesday, but I think it's worth amplifying exactly what's going on here. So, and I have to be a little patient with the reading. So, so the text of the opinion says the existence of facts supporting the legislative judgment, i.e., in this case, the legislative judgment would be the policy you're pursuing. The existence of facts supporting the legislative judgment is to be presumed for regulatory legislation affecting ordinary commercial transactions is not to be pronounced, for regulatory legislation affecting ordinary commercial transactions is not to be pronounced unconstitutional unless, in the light of the facts made known or generally assumed, it is of such a character as to preclude the assumption that it rests upon some rational basis within the knowledge and experience of the legislators. I don't know who drafted this sentence. In terms of double and triple negatives, it's truly a mess, and none of your papers should resemble this mode of expression. But the essential point being made here is that the ordinary presumption henceforth for judicial monitoring of public regulation of economic activity has to be that we're going to assume that the facts and evidence are reasonable, rational facts. It's not. We have to assume that the legislators are acting as policymakers, that they're going to inform themselves. They are informed about the ends they're going to pursue. They're not engaged in legislative activity because they're doped up or stoked up or whatever. I mean, they're doing it for some serious purpose. Courts will not be in the position to judge and rejudge the facts upon which much of this legislation is based. So rational basis is about as low as you can go in terms of assigning it as a standard of evaluation. It's about as low as you can go in terms of crediting, having confidence in the lucidity of legislative motives. Now it's true there are a lot of nutty people in state legislatures, and it's true that state legislatures often engage in kind of hilarious procedures. And I know actually when my dad taught political science in Chicago, we liked to take students down to Springfield at the end of the term to watch what happened to the state legislature, because in many states, you have to pull, the session has to end, it's given some date. Midnight, I think in Illinois, it's midnight on June 30th is when the legislature has to adjourn by constitutional mandate. Of course, that depends on the clock. So if if you pull the plug on the clock, you don't know what time it is. So there's kind of utter chaos. So there are lots of reasons. Or suppose you lived in a state like Arizona, even today. I mean, there's lots of reasons to assume a lot of some measure of legislative idiocy. But I think if we're actually going to pass a law, the ordinary assumption is that enough rational basis consideration has gone into it. So in effect, this is the first part of the standard. We'll say a little bit more about how Wickard versus Filburn, modifies and expands this, a few years later. But it says laying down a rational basis test. Judges are just incompetent to review all the facts that have gone into legislation. And then there comes the accompanying footnote, which is a little bit excerpted here, but not too much. So the footnote modifies and in some ways constrains the assumption of constitutional rationality that the text applies. There may be narrower scope for operation of the presumption of constitutionality. Okay, so there may be narrower scope. These are occasions where we might want to apply a different standard when legislation appears on its face to be within a specific prohibition of the Constitution, such as those of the first 10 amendments, which are deemed equally specific when held to be embraced within the 14th. So here's an early statement of what we come to know as the incorporation doctrine, right? There is some body of constitutional rights deeply entrenched in the text of the Constitution, and we are now entitled under Section 1 of the 14th Amendment. We haven't clarified is this, privileged immunities, due process, or equal protection, but Section 1 of the 14th Amendment gives us a basis for applying, in fact, gives us a strong basis for applying the specific protections. I think it might be better to say the first 8 amendments, leave 9 and 10 out of it, but people are only starting to think about the Bill of Rights. In the 1930s, people are actually only starting to think about the Bill of Rights as having a coherent integrity. Bill of Rights is, I think I said last week, had not been a major subject of litigation. Reynolds versus U.S., the Mormon marriage polygamy case was kind of the exception. But the 1930s, in part because it's, people were celebrating a century and a half of the Constitution, 1937, 1939. I think there was actually a Bill of Rights train and kind of an interest in it. So the idea of the Bill of Rights as a discrete, coherent entity is starting, in some ways, it's starting to develop almost in cultural terms as an artifact or a byproduct of this period. So we start with a kind of strong statement, which sounds a lot like the incorporation doctrine. And then we go on with some disclaimers which don't matter for the moment, but may matter in the future. And again, the phrasing is, it's a bit on the turgid side, but still worth taking into account. So it is unnecessary to consider now, so the emphasis here should be on now. It is unnecessary to consider now whether legislation which restricts those political processes which can ordinarily be expected to bring about repeal of undesirable legislation is to be subjected to more exacting judicial scrutiny under the general prohibitions of the 14th Amendment than are most other types of legislation. Nor need we inquire, let's insert a now again, nor need we inquire now whether similar considerations enter the review of statutes directed at particular religious or national or racial minorities, or whether prejudice against discrete and innocent minorities may be a special condition, which tends seriously to curtail the operation of those political processes ordinarily to be relied upon to protect minorities, and which may call for a correspondingly more searching judicial inquiry. Again, this is not the most lucid prose. Breaking up those sentences might have been helpful, a little dramatic emphasis here and there. But in effect, what the court is saying, is we're thinking about, in a sense, what's going on here is a kind of a signaling activity. For now, we don't have to need to think about this matter because we're only talking about filled milk, right? There's no need to resolve this in the case. So in this case, actually, this could be an example of what is sometimes called obiter dictum, which means Habib.
And I know that in the judicial sense, it means that it's just something that's not essential to the logic of an opinion. It's just superfluous language. Or I don't know the exact.
Yeah, well, kind of in a sense, obiter, a dead dictum. I mean, it's kind of lying there dormant. It's not something you're acting on. So it's used in terms of reading legal opinions. If something is labeled obiter dictum, it means the judge is saying something. It's not really authoritative. Doesn't really have any bearing on what we're doing, or maybe wholly superfluous to what the legal action is. Except here, it's fairly clear that this passage, again, it's not murky language, but could have been more lucid, could have more perspicuity, to go back to that 18th century phrase. Could have had more perspicuity. But in any case, now the court is laying down, I think in a sense, signaling a position which in some ways is inviting future litigation. I think that might be too strong. It's not like what the court does now, I mean, you could make a good argument now that with Alito replacing O'Connor and the nature of the conservative majority on our sitting Supreme Court having shifted in some way significantly, losing a swing voter for an ideological voter, that the court does a lot of signaling of what it wants to decide. And that raises some really interesting questions. Maybe we'll talk about at the very end of the course about the current state of the Constitution. But here the court, in fact, is saying, in the economic realm, we're going to move away. We're going to assume rationality. We can't judge and rejudge, the facts underlying the case. And, the facts here, I mean, actually, I skipped over this point, which is at the very top thing on the outline. But, since I mentioned the other day, facts in the 1930s, I mean, in terms of legal policy, in terms of American jurisprudence, facts are going to start to take on a different quality because now you do have this notion of, legal realism, and a lot of academics out there and social scientists out there producing data, producing evidence, discussing policy considerations which now seem relevant to the law. And in fact, one of the issues that comes into play in the litigation in the 1930s is is a kind of broader understanding of the nature of the minimum wage. Why, if you want to have minimum wage legislation, what is it you're trying to do? So new arguments are developed. Those, in a sense, start to constitute facts that upon which legislators need to act if they're to pursue public policy objectives, but which judges, because of new doubts about their competence, have to stay away from. So, for example, in the realm of minimum wages, there's a kind of effort to say that if you want to justify minimum wage, you might really want to ask, what is the fair value of the services the laborer is providing? Is there some way to measure, instead of just assuming a race at the bottom in terms of setting wage scales, particularly in times of unemployment, maybe there's some other way to calculate what is the fair value of the labor being imparted. It sounds a bit Lockean, I suppose, if you think about it. Or a different factor, which we'll see again is in a couple minutes, would be the kind of argument we see in Wickard versus Filburn. Let's think about the national effect. Let's think about the aggregated effect of the individual activity that we're trying to regulate. So it may not just be a matter of imagining or idealizing one worker, one employer, coming up with some formal notion of what the relationship between them ought to be. What we really have to do is think about the consequences. And the argument here being made, in effect, is that judges don't, lack the requisite capacity to assess those consequences, to assess the new social science, to think in the sphere of legal realism in the way that legislators are going to do it. Doesn't mean legislators always get it right. They're free to make their mistakes, but that's democracy. And then that's why you have elections. If they screw up, you vote for the other party and try something else. Okay. So the other thing to note about this is to focus on this. So Carolene Products looks very prescient because it identifies the real issue here. It doesn't imagine that the struggle, as I just said, is about an individual versus his employer. There is a kind of legal realist, implicitly kind of aspect or critique of its own. We're going to try to imagine which groups, within society. Let's think about the larger society. On what occasions should courts be most vigilant? And the argument here is that when the political process, I won't say breaks down, because that's pretty judgmental, but when the political process is inadequate to fairly, adequately, justly represent the interest of discrete and insular minorities, when they have no hope of winning elections and therefore cannot rely upon the ordinary mechanisms of democracy to help them, alleviate whatever burdens or discrimination they're suffering, then the basis for heightened scrutiny of legislation, heightened judicial scrutiny of legislation that may have unjust consequences, it becomes much more legitimate. And this becomes a major motif in, just one second. This becomes a major motif in contemporary constitutional theory. You might remember we talked a couple times earlier about Alexander Bickel's famous book, The Least Dangerous Branch, which was an argument, in a sense, for a kind of what Bickel called the passive virtues, for the idea that courts should be somewhat slow to become responsive to it. But one response, and kind of what, I won't say an alternative, but one response to Bickel, it's actually a book done by a former Stanford law dean, though he wasn't very happy here and went off to Miami, John Hart Ely, but has an interesting book called Democracy and Distrust, which in a sense takes the logic of the Carolene Products says, maybe what we really want is a judicial process that really does emphasize opening up the political passageways and making sure that they work properly. Winston?
What exactly were the attitudes of the moderates on the court towards an expanded rational basis test, and were they really? I mean, how concerned were they about potentially using that test broadly, allowing Congress to run amok, basically?
How concerned are they about allowing Congress to run amok, or so just to repeat for our fans in podcast land or whatever. So how concerned are they the rational basis? I think they're pretty strongly concerned. I think there is a pronounced movement on the court, particularly with the new appointments that come along. I don't want to say to get the court out of the economic business, because economic cases are always going to come forward. But in terms of the constitutional regulation of public policy decisions about the management of the economy, I think there's a pretty broad agreement here. And that actually thinks that's a good prompt, because it actually gets me to the next set of points. And this wasn't planted. This is wholly spontaneous. So, just intuitive on Winston's part. So that's Carolene Products. I wanted to think of it as a signal, because next week when we turn the whole issue of desegregation, it'll be worth asking, how did this play out operationally? So once you get past 37, 38, the initial shifts, there were kind of three further points I want to make before we transition here. I'm half tempted to try getting the computer on again, but c'est la vie. We'll catch up with the visuals on Monday. So the first thing that happens is FDR gets to remake the court in his own image. The four old men, or let's say the 9 old men, but particularly the 4 conservatives, were old men. They were aging. So too was Cardozo. Actually dies in 1938. So it wasn't just not just conservatives, but it's one of the most dramatic episodes, and I think I mean episode here pretty literally, in the history of the Supreme Court, that from 38 to I think 1941, 1942, FDR gets to make 7 appointments, some which would have lasting significance. Hugo Black, I think, is actually his first appointment to the court. Felix Frankfurter replaces Cardozo. At that point, there were 2 Jewish seats, although once Brandeis leaves the court, only be Frankfurter. Frankfurter, by the way, come back to Winston's point, and we see this in the flag salute cases. Frankfurter is arguably, ideologically, conceptually, the one justice who feels most strongly the imperative of the court being highly deferential to Congress, or actually to legislative bodies more generally. And that comes out in the flag salute case, which we'll try to say something about in the Gobaitis case, and then also actually in Barnett, the second flag salute case, that comes up pretty strongly there. But the key thing is the court, as an institution, just shifts fundamentally. Now we're in this whole situation, which you may want to talk about at the very end of the course, where the whole idea of justices timing their appointments and timing their retirements in order to affect the appointment sequence, it seems to me raises some interesting and in some ways troubling questions about the whole way that Article 3, tenure during good behavior operates. And we'll come back and say something about this later in the court. But clearly there's a dramatic transition in the character of the court takes place in this period. So the path is open. So that's point number 1. Point number 2, Dr. Win the War is kind of famous. It's a kind of famous saying about the New Deal that, remember Roosevelt, of course, was elected for 4 terms, serves 12 years and a couple months or whatever. And then dies in April 1945. But much of the agonizing about the extent of the national regulation of the economy in a variety of ways by national government, much of that is superseded by the onset of World War II and by the beginning of the process of rearmament that antedates American entrance into the war in 1941. I mean, there's an immense naval building program, just a whole variety of things. And the key thing here is once, this is the beginning of what Dwight Eisenhower would later call, when I was a freshman in high school, the origins of the American military-industrial complex, the whole idea that, the United States is the arsenal of democracy, and then as the world's emerging superpower, that we would set out to be the mightiest armed force on the earth. I mean, not with an army more numerous than Russia has, but, we have a couple of oceans to provide some measure of security. And so on. But, in one sense, the whole idea of, the kind of constitutional controversies about the role of the national government in terms of promoting economic recovery were superseded by, the fact of war. Now, it's you make, I suppose, a kind of quasi-Keynesian argument about this, but it's the massive level of public spending, in some ways overtakes and reduces the significance of a lot of the constitutional questions, because now the national government is in a wonderful position to drive economic growth because of our external commitments. The other point to be mentioned here, by the way, is, and this is a little more subtle, but once that takeoff point is reached, once the national government becomes a source for economic development in terms of supporting the arms complex, technological innovation. My colleague Richard White got in some trouble over at the Hewlett Foundation with the Hewlett family at a dinner recently, where he said it's not about the garage. What really drives technological innovation, Hewlett Packard would qualify. It's really the force of Washington's interest in developing computers is as important as anything else. So it's in other words, it's a lot of ways the growth of the computer industry here, now dominated by libertarians, in our time, is nonetheless driven by big public policy commitments, where the government and in general, the Pentagon in particular, is the driving force. But the constitutional point I want to make is once the government is pouring that much money into the economy, once its revenues take off, and once it accepts kind of the logic of Keynesian economics, then constitutionally the federal government gains the enormous power to dictate how policy is going to work at the state and local level just by virtue of the funding power. There's lots of things the national government can get other jurisdictions, state and local, to do, not because they have constitutional authority over it, not because formally it's part of their legislative responsibility. It's just they have so much money which can be spent for the general welfare of the United States. Think about the realm of education as a non-trivial example, that you can set national policies in a way that will reshape the very nature of American federalism. So that's another basic point to keep in mind. And then finally, the interesting case of Wickard versus Filburn, and sorry, our slideshow has crashed, and I'll call Hennessy after the lecture to find out what's wrong with this. But in any case, Wickard versus Filburn is that famous case from 1941, where, it's Roscoe Filburn, I think is his name. So it's the classic case, farmer, I think in Indiana. Somebody correct me if I have the wrong state. I think it's Indiana. I'm sorry? You think it's Illinois? Downstate? Yeah. In Illinois, if you're outside Chicago, everything's downstate. So, you can go 20 miles, you're downstate. Kankakee, definitely downstate. Anyhow, so here's Filburn. Filburn is, raising wheat that he's using, huh?
Ohio?
Well, that's another state. Yeah, I don't know.
Is that the target state, though?
I can't remember. So, be that as it may. So here's Filburn, raising wheat for his, somebody. Well, I banned computers, so we're not going to look it up, right? So be that as it may, raising wheat to be used by, in grains to be used only by his animals and his family. Then you could distinguish between them, pretty easily. But he's raising more than he's allowed to do under the Agricultural Adjustment Act. So his argument, and I don't know enough about who's actually picks up, if Filburn just was driven by his own convictions or if there's some kind of test case aspect of this, but his argument is he's not engaged in commerce. He's self-sufficient. He's kind of fulfilling a Jeffersonian ideal. The Jeffersonian ideal is we should, farmers should be, called in the 18th century, they should be competent to do this for themselves. He's not engaged in commerce. He's not buying anything. He's just producing. He's producing for his own use, but he is exceeding the allotted value under the Agricultural Adjustment Act, or I guess as it's reenacted after 1937, of how much he's supposed to produce, and he's so he's going to be fined for this. Is the fine valid? Well, the answer is yes, and the rationale is that the answer should be yes, because we don't care about Filburn per se. It's not a question about the individual right versus, some authority. We want to generalize. We want to aggregate the consequences of his behavior. If we're thinking about how do you regulate the national economy, if you've reached the decision that, we need to have some caps on production in order to improve and stabilize the nature of the market, by growing more than he was supposed to grow, Filburn is depriving, some other producer of the value of, of having wheat sold to him. And again, we don't care about Filburn, but if you generalize Filburn's behavior, if you aggregate it, then you'll see we'll have a kind of, it'll have a potent national effect. And so, the phrase that's used here, I mean, again, there is, the rational basis thing comes in, but Wickard versus Filburn also kind of helps to develop the idea. I think the phrase comes in the opinion. When there's a substantial relationship between the activity in question and commerce defined more broadly, that's a sufficient basis. That's an adequate basis for public regulation. And again, what it has to do is you have to go back to the prior standing definition, which says commerce is commerce, and it's about taking good A from point B and selling it in point C. It's essentially about the interstate movement of goods, nothing more, nothing less. All these other factors relating to production, relating to any number of aspects of the whole economic enterprise. That's another category. Commerce, if you define commerce narrowly, it's just about the shipment and sale of goods per se, without these other dimensions. Then it's not an issue. But in Wickard versus Filburn, you think about the net effect. You think about the substantial relationship which exists between even this individual act, when generalized to a whole mass of people, and the net economic consequences. So Filburn loses. And of course, there's a great question to ask now is, and just to make a little aside here, and I'm not the biggest expert on this, but I think this understanding is correct, is that, the expectation in the legal academy that the Sebelius case, the Affordable Care Act case, would obviously be decided in favor of the legitimacy, the constitutionality of Obamacare. That it wouldn't have to, it could use the tax power, but it wouldn't really need, which is what Justice Roberts wound up endorsing, the penalty imposed on non-compliers treated as a tax, which is perfectly legitimate. But I think most commentators would have said the whole principle of Wickard versus Filburn, the sustained relationship aspect of healthcare, which of course is a massive industry with massive public consequences, for which each of us as taxpayers, assuming you or your parents are taxpayers, is a fairly plausible assumption, will have some consequence, will help to bear the burden. It seemed to a lot of people to be a no-brainer, which is why it's going to be a story to be prepared to be surprised, when the news actually happens, and you have to see what kind of novelty exists. But I always thought you just draw a direct line from Wickard to Sebelius, and it was kind of a no-brainer. I think a lot of academics made the same assumption. That turned out to be wrong. Okay, so we're going to leave the economic aspects of the New Deal behind, which is probably good for me, and hopefully good for you. And what I guess I want to do now, and I have about 9 minutes left, is to try to offer a bit of a segue into the theme that's going to concern us, particularly next week. But also a bit beyond that as well, which is that, going back to footnote 4 from Carolene Products, the dominant theme in American constitutional jurisprudence after 1940 becomes the whole question of extending the equal protection of the laws, in part by incorporating the Bill of Rights across the nation. Really moving from the concern with the issues that had vexed American politics from the late 19th century, let's say throughout the Lochner era, broadly defined, to come into the age of what we now call the age of human rights. Of course, when we use the phrase human rights, in effect, we are globalizing how we think about rights. That's the whole concept of human rights, is that the rights that we want to see honored and respected and gained and pursued around the world should not be dependent solely upon particular legal doctrines that reign within individual constituencies. So we have a broad conception of the whole idea that we have a modern conception that says human rights are so valuable, so essential to who we are, wherever we live, whatever society we reside in. That either you want to live in a society where you enjoy them already, or if you don't, then efforts should be made to make it possible for you to enjoy them. In the American case, of course, what we care most about for the period after World War II will be the origins of the Second Reconstruction, will be the movement towards racial desegregation in the South, and then all the other issues that came out of the aftermath of Brown v. Board and the Civil Rights Act and the Voting Rights Act, and affirmative action and things we still agonize and dispute a lot. But one way to think about this is to understand, as I said the other day in terms of thinking about the Depression, there is a global context for what's taking place here. And our sensitivity to issues of constitutional rights and human rights alike is driven, was driven by this kind of this kind of broader perspective. So the slide I meant to show, I guess I'll do this all on Monday, and that maybe we can work it into the tape. Who knows? Ex post. Is there's January 1941, FDR gives a famous speech in which he talks about the four freedoms, and this is actually the base of the Atlantic Charter speech. And he identifies four freedoms as being fundamental, and also really, and not merely American, but to be global in nature. Freedom of speech, freedom of religion, freedom from want, freedom from fear. It's essentially, and the famous illustration of this, which I meant to show, but you guys have probably seen some of this, comes from, anybody know, other than Habib? How much you use your imagination? It comes from Norman Rockwell. Does that name mean anything to anybody in the audience? I'm sorry? Yeah, it did kind of classic Americana. He has a famous one of the Cubs dugout, which is, of course, this is the year the Cubs are going to win, so we're not going to worry about anything, once after spring training. But so Rockwell does a famous set of four paintings illustrating the four freedoms. Religion, speech. The speech one shows a guy who looks like your ordinary working class carpenter standing up in what looks to be a New England town meeting and voicing his opinion. Freedom from want, I'm pretty sure, is a Thanksgiving dinner. I have to think about the others. Anyway, that was supposed to be the visual for this. I'll show it to you guys on Monday. Anyhow, so the idea here is that a major as the United States. So this is January 1941. So you guys remember World War II. Begins September, well, at least in Europe, back earlier in Asia if you want, but in Europe begins September 1, the Nazis invade Poland, September 3, Britain and France declare war on Germany in support of Poland. That's followed by, Poland is conquered very rapidly, the Russians come in, occupy half of Poland from the east in their usual way. And then there's the so-called period of the Sitzkrieg, where not much is happening. In Europe, it's not clear will the war be extended or not. But then in the spring of 1940, the Germans go into the Low Countries and they go into France, and that's that Blitzkrieg, kind of lightning war based on use of tanks and paratroopers, replaces Sitzkrieg, kind of a standing war where you're not clear there's going to be any activity at all. And Roosevelt's policy, and we'll talk more about this in a different context down the road, Roosevelt's policy was to move the United States as close to being able to support Britain, which becomes the one remaining Allied power after the fall of France, as is possible. For political reasons, Roosevelt is either somewhat artful or arguably, if you're a kind of hardcore right-wing Republican, deeply duplicitous about the methods being used to kind of transfer resources and support to Britain. Part of the story, though, is as the United States is moving towards war, not quite in it, but it's fairly obvious it's going to come. Part of the story is the United States Roosevelt, the Roosevelt administration, and the New Deal more generally, starts to present a kind of a new image of the United States as a purveyor of liberal democratic values across the world. Remember I said the other day that when we go back to think about the Depression, it's not enough to think about what are the constitutional and political issues in the United States that will get the country off depression. One has to understand the 1930s. It was by no means obvious that democracy was going to be a winning formula for government. It's perfectly plausible to think that democracy will be superseded by fascism or communism or some more authoritarian forms of government. And so the whole idea of how do you present the United States, what kind of a war, what kind of a struggle is it we're waging, becomes central to the Roosevelt administration's portrayal. So when Roosevelt gives this speech about the the four freedoms, it's on the one hand it reaches into our constitutional tradition. It does talk specifically about First Amendment rights, but of course it is also more expansive. Freedom from want, the legacy of the Depression, and freedom from fear, in opposition to the kind of the extensive secret police tactics of both Nazi Germany and the Soviet Union. Last point I think I'll make on this morning. We actually have 2 minutes here. We started a little bit late, but we read about the flag salute cases. So just a quick word. You guys probably did this in the reading, but the flag salute cases, in their own way, are kind of the great emblem of what this transition means. And the basic story here, the story is kind of tied in with the narrative. I mean, the basic story is that I have the Gobaitis. I have a slide of the Gobaitis kids, which I'll show on Monday. Is that the original decision in Minersville versus Gobaitis took place right after the fall of France, and the opinion writer was Felix Frankfurter, who of course is Jewish and is very close. He is probably the one member of the court who was personally closest to FDR. And actually, say in some ways, he sees himself actively supporting FDR's policy. And believing that in this time of peril, that patriotism comes first and foremost. Frankfurter writes an opinion which upholds the Minersville School District. Says it's legitimate to punish the kids and do this, that, and the other thing. It's kind of a great patriotic impulse. Some commentators say it's really, in some ways, it's Frankfurter's response to the fall of France. Which may or may not be true. The interesting thing about this, though, is from the start, the opinion was deeply controversial. It wasn't popular in the administration because the administration, I think, was already moving in the direction that FDR would articulate publicly with the four freedoms in the Atlantic Charter, the idea that as the United States moves towards a position vis-a-vis other nations, what we want to do, we are here in behalf of freedom. Why do we want to victimize little kids who are religiously scrupulous about not having to swear allegiance to false gods? The essence of Billy Gobaitis' little note. They'll show you on Monday. And that kind of funny story. Last thing I'll say today is there's a kind of funny story here, which is that not too long after the opinion, Frankfurter was invited to a wedding from the Graham family that owned the Washington Post for a long time. Forget exactly who was being married. It was hard to get the wedding going, literally, because so many people were arguing with Frankfurter about the decision. It's kind of, so that's kind of a funny little story. It's a whiny to say, we're going to have a wedding here, so let's kind of get down to business. But the controversy over it shows already how American sentiment was trying to move. It took a good 3 years to come. It's essentially, the Barnett case is essentially the same case. There's no factual difference. It took X number of months to generate another case and get it up to the court to be heard. Last point, arguably, Jehovah's Witnesses were the first concrete example of discrete and insular minorities. It wasn't just about African Americans. That raises many more difficult questions. So a great example is what's a discrete and insular minority? Jehovah's Witnesses, kind of deeply imbued with powerful religious passions. They weren't so pleasant in those days. They wouldn't just knock on your doorbell and ask you to read something. They'd set up record players in public spaces denouncing the Catholic Church and other religions. They were a little more aggressive at this time. So, it wasn't like a bunch of sweet little old ladies say, oh, no, thanks. See you some other time. But they mark a really interesting point of departure for thinking about what happens to the concept of discrete and insular minorities, and that's where we'll pick up next week.
This program is brought to you by the Stanford Humanities Center. For more information, please visit us at shc.stanford.edu.
For more, please visit us at stanford.edu.